Steve Bannon's defense team filed a new motion. They're saying that the government prosecutors are making blatantly false statements about what happened leading up to this case. And of course, are you surprised at all? Is anybody surprised? Sounds about right. Let's see what's been going on in the Steve Bannon case. We see here several different entries came about over the last few days. On March 15th, we talked about this one, a response by Steve Bannon about the motion for leave to file the surreply. So this was coming from the U.S. government. They wanted permission to sort of file an additional reply. And Bannon's defense team said, yeah, whatever, we don't care, no objection, file it away. We want to see what you have to say. In fact, I'm curious to get it. Send us a copy. And so that was something that we covered previously. We have on March 16th, this is when we had oral arguments. And we saw a little bit about this on Twitter. There were some people reporting on it. We'll take it down when we learn more about it. But I want to show you what happened because kind of not much. Here, we'll take a look. We see all of these people were there. Court reporter, David Scone, Corcoran, Costello, U.S. attorneys, Vaughn, Cooney. We've got Molly Gaston. We're all there. Defendant out on personal recognizance. So he's sort of, free as we know. We've got sort of different scheduling dates, supplemental briefs, government ex parte filing, and others. So we'll talk about those. But here is really what we were in court for. There were several different motions that they were arguing about, motions 26, 28, and 29. We're going to take a look at what those are specifically. So we'll just call these the three motions. And so these three motions we're going to see were sort of ruled upon differently. We have the first of the three was taken under advisement. This means the judge has to think about it. The judge said, I heard both sides here. I can't issue a ruling right now, but why don't we brief some of these issues? Why don't you send me some more information, send me a couple things to look at, and then I'll make a decision and I'll issue a ruling, typically by written order, further down the line. So for the first of the three motions, under advisement, judge still deciding. We get a second motion, motion 28, denied in part, granted in part, for reasons set forth on the record, and don't know exactly what that is until we get some more details on that. So on the record, presumably meaning that that was what they talked about in court, in open court, but of course this is federal court, so we can't listen in. People can't record that. And so we'll see how this sort of fleshes out when we know what that was. But so Bannon's motion in part, granted in part, denied in part. And so some people looking at that as a big win. Some people looking at that as it's too soon to tell. Other people saying maybe it's a loss, but we don't really know yet. And then we have the third motion, the motion number 29, the third of the three, also taken under advisement. So kind of have two motions that are sort of on the judge's desk. The judge is going to mull it over the weekend or however long, and then we'll get some rulings on it. And then the other one was sort of granted in part and denied in part. And these are motions about discovery. We're going to dive into what these motions are here in a minute. But you can see from the rest of the proceedings that took place on the 16th, we've got some scheduling deadlines. We've got defense replies due by April 1st. And so we'll see some more filings back and forth as those deadlines come and go. Government's going to respond, the defense is going to respond, and we'll go through those. We are also going to see on March 17th, we have another surreply. And so a surreply, as we've talked about here previously, is kind of something that's a little bit abnormal. Typically, the way that this works is you have a motion that is filed by a moving party, where one side says, well, I want a motion for a continuance, or I want a motion in limine here to preclude certain evidence from coming into court. Here, there was a motion in limine, a motion to limit, really, to exclude evidence or argument about good faith reliance on the law. And you can see that this was filed by the government. This was a government's reply in support of its motion. So here we've got the government filing a motion. They're saying, look, judge, we want to sort of limit what can come into court during testimony, a motion in limine. We want to exclude any evidence, any argument from Steve Bannon and his defense team saying that they took reliance in good faith on law or advice of counsel. They don't want to allow Steve Bannon to come in here and say, look, I didn't show up. I didn't respond to this subpoena. I didn't comply with the fake January 6th select committee because I was just following the advice of my lawyer. The prosecutors are like, that's a pretty good argument. So we better limit that. Let's come up with some reasons and why he shouldn't be allowed to make that argument. And so before the trial starts, they got to make a motion and file that. And that's what this is. They're saying this is a motion in limine to exclude any of that stuff from coming in. And so that's their motion. Typically, the way this works, they file a motion, the non-moving party files a response to that motion. So they'll say, we want this done. Well, no, we don't. This is why we think that should not be done. Or they can say, sure, yeah, no problem at all. No objection, go ahead and file it. Or they can object to it. And then we have a motion, a reply, and then the moving party gets a motion, a response, then the moving party gets a reply that goes on top of it. Because since they're the moving party, we give them the last word. We say, all right, they responded and they've got some pretty good points, but why don't you take the last word and you issue your reply to their response, and then we'll make our ruling. The judge will typically make their ruling. In this case, what we have now is a surreply. So it's sort of like another layer on the sandwich. And they say, well, all right, they replied. Now we're going to surreply and respond additionally. And so they typically, you need to get permission from the court in order to do that. And back during March 16th, we see that apparently that was granted. And Bannon's defense team filed the surreply back here on March 17th. And so, all right, what are we talking about now? This is a surreply to motion 29. And I called these the three motions. Let's learn a little bit more about them. We've got 26, 28, and 29. And these are different sort of discovery and pretrial issues. We can see that all of these issues came up way back in February. February 4th, we saw several different things filed. 26, the first of the three, we've got the motion to compel disclosure of government efforts. So this is being filed, you can see here, by Steve Bannon. So Bannon's defense team, they're submitting a motion. They're saying, look, judge, we need certain evidence in this case. The government has all the files, right? They've got the big briefcase and the binders full of, whatever, where they've got police reports and body cameras and FBI agents, put all their notes and where's Waldo circles in there. And so it's very, very important that we see that so that we can begin building our defense. And they're not giving it to us. And so therefore, judge, we need a motion to compel them to disclose this stuff over. And what do they want here specifically? Efforts to obtain telephone and email records of Bannon's lawyers. Pretty important stuff. Why is the government going after my attorney's private emails and private records? Not appropriate at all. We have something called attorney-client privilege that is supposed to make sure that those communications are sacred. And that is not appropriate. So here we see that motion was filed by Steve Bannon and his defense team. Motion 28 was very similar. Another motion to compel discovery. And here it's a whole slew of additional issues. We got multiple exhibits, 1 through it looks like 12. And so this one, I believe, was granted in part and denied in part. And so until we get some specifics on this, it's going to be hard to tell exactly what the judge was ruling on, saying this is allowed, this is not allowed, we're going to let this in, or you can ask questions about that. And so we'll get some more details on what that is as we start to get rulings from the other rulings that are currently under advisement. We also see that one was also filed by Steve Bannon. Okay, so the 28 motion filed by Steve Bannon, a motion to compel discovery. But Bannon was not just the only one filing motions on the 4th. We also see this one came in. Motion in limine to exclude evidence of relying on advice of counsel. This one was filed by the USA, as to Steve Bannon, right? They're filing this saying, judge, we've got to make sure that he can't talk about his lawyer and just default to, just following the advice of my lawyer. Because that might be a very good defense, and they may not win their case if he's allowed to talk about those issues. So they want to stop that from happening. So now, since all of that took place, they filed the motion. Bannon and his lawyers responded to the motion. Then there was a reply to the response. And now, since the reply came from the prosecutors, from the DC U.S. Attorney's Office, Bannon and his defense team say, when they filed that reply, there's a bunch of stuff in there that is totally blatantly false. Everything that they replied to in there is problematic. And so when they had oral arguments back on the 16th of March, they said, judge, we need permission to go and file a surreply. We've got to reply to their reply because they just made up a bunch of nonsense in there. Can we have permission to do that, judge? And the judge said, sure. I'm open to filing surreplies in this case. I've been just doing it all over the place. Everybody gets surreply. If you ask for permission, go ahead. And so they did, and that's exactly what we're going to look at here. That's this motion. You can see this is 9 pages long. This was filed on March 17, 2022. And this is going to be a big, long title of this document, but Now that we have a little bit of background, I think it might make sense, I hope. Here we can see this is United States of America versus Steve Bannon taking place, U.S. District Court over there in Washington, D.C. And this is the defendant's surreply. So that is Steve Bannon's motion. He's filing this. The defendant, Steve Bannon, is a surreplying here to the government's reply in support of the government's motion in limine to exclude evidence or argument relating to the good faith reliance on law or advice of counsel. So a big, meaty, chunky legal run-on sentence, but hopefully we can see what's happening. Steve Bannon's lawyers are taking the last word on this issue since the government, in their reply, came up with a bunch of blatantly false statements, as we're going to see. Here, this is how this is broken down. It says, during oral argument on March 16, 2022, Bannon was here, and we were in the middle of these oral arguments and asked the court for permission to file a surreply in response to the allegations that came up by those prosecutors in their motion. The court granted that request from the bench and just said, yeah, sure, no problem. And the information set below is our reply. And it starts like this. False claims made by the U.S. Attorney's Office out of D.C. They say, in the government's recent submission in support of its motion in limine, so the government's attempt to stop this evidence from coming in, they wrote to you, Judge. They said they took the position that Steve Bannon and his lawyer, Robert Costello, pursued a, quote, bad faith strategy. And those are kind of fighting words when you're talking to lawyers. Are you calling me dishonest? Are you calling me unethical? I'm somebody who advocates strenuously for our clients, but don't ever cross ethical bounds. And so seems like bad faith means like you might be implying that, are you? Here he says they claim that Bannon and his counsel Costello made false claims. Oh, those are definitely fighting words. Says we respond to each instance where the government alleges some wrongdoing on the part of Bannon's counsel and dispose of each and every one as follows. Let's get into it. Now, there are 12 of them in total for the sake of time. We're going to only look at about 6, but there's an additional 6 if you'd like. The full motion is available all over the place. But certainly we can jump into here and see that number 1 starts. And this is what Bannon's defense team says. They say here, on page 2, the government states that the defendant, quote, suggests that the committee did not properly serve the subpoena. Now, this might sound a little bit boring, right? Service of process and serving subpoenas and all that stuff. But this is pretty important, right? This is a legal procedure. And before legal actions can take place, you got to make sure that people have due process. They're notified of the proceedings, that they are a party to it, right? Or they waive their right to be there. In other words, the court proceedings can't theoretically go on without somebody, knowing about it. We wanted that to not happen here in this country when there would be prosecutions that would take place in other parts of the world, and somebody would wake up and be like, oh, you've been convicted under the king. What? Of what? I didn't even have a chance to show up. And they're like, well, that's too bad. You're going to jail forever now. That's why we have notice and things like that. And so here they're arguing about over some of these things, but the crux is that it's not about the service. It's not about the subpoena per se. I mean, it is about these things because this is a technical lawsuit, but we're also talking about, or technical prosecution, but we're talking about the allegation that's much broader, which is your defense lawyers are liars and they're acting in bad faith and they're cheaters. And they're going, how dare you? And so they're going to go through this. It may seem like minutia, but it's all important. They say that the government wrote in their motion, they're saying the defendant, quote, suggests that the committee did not properly serve the subpoena, right? Saying that they're suggesting, see that the committee did not properly serve the subpoena. And so it's not even about the subpoena at all. It's about the allegation that they made a suggestion. They say, we didn't make a suggestion like that. Weirdos. They said, we merely noted the subpoena was sent to counsel before counsel had permission to accept. That's what we said. And that the affidavit of service claimed it was served and accepted the day before counsel for Bannon actually accepted service. We've not challenged service based on that misstatement by the government. Right? So very, very, sort of splicing and dicing of the language happening here. The prosecution is being very sloppy. They wrote in there, the defense is suggesting that the committee did not properly serve the subpoena, and Your Honor, this is, and the defense, we didn't suggest that at all. Where did you see we suggested anything? And they went back through the record. They say, we made no such claim. We just noted the subpoena was sent to counsel before and we didn't have the opportunity. If you are sort of taking what we said and iterating it into this new idea that we may come up with an argument, you may infer that our suggestion, we didn't suggest anything. You're taking what actually happened and you're coming up with your own suggestions. And so don't put that in a motion in front of this judge. We're going to receive it and reject it. Number 2, they continue on. They say on page 2, the government makes an irrelevant point. They say the defendant, here Bannon, was a private citizen. Right? This is their language in their motion, saying that, quote, semicolon, although he had been in a White House advisor for 7 months at the beginning of former President Trump's term. And they're saying, okay, what the heck does that have to do with anything? They say this statement, while factually true and actually consistent with the false legal claims Chairman Thompson was consistently making in his correspondence, they say it's irrelevant to the question of whether Bannon can be guided by the invocation of executive privilege by President Trump. Irrelevant. It's conflating the issues. They're saying this privilege is something that applies and it's all in it. It's been clearly invoked, and Bannon is operating under the premise that it has been invoked and that it is governing. And they're saying, well, you know, he was the former advisor for 7 months, but he was a private citizen at that time. And they're saying nobody's saying that is consequential at all. Nobody's making the argument that he only had the privilege when he was employed or that he lost it when he was on. That's not the claim that's being made. So they say it's true, but it's irrelevant. Point number 3. On page 3, the government makes a very important, and this is where we see it, blatantly false statement that the committee provided the House of Representatives with established rules for the deposition. And they point out very clearly, they say this statement is proven false by the discovery that was provided to Bannon's counsel by the same government officials making this false statement. So let's break this down for a minute. They wrote, the committee provided the House of Representatives established rules for deposition, saying here that the January 6th Select Committee gave the House of Representatives rules for deposition. Bannon's defense team is saying, well, look, you gave us discovery, okay? You gave us files from your briefcase that you said had the pertinent things in there that we needed for our case. Those weren't in there. They write, the government provided Bannon's counsel discovery an FBI 302 report of investigation dated back November 2nd, 2021, included an FBI interview of Doug Letter, general counsel for the House of Representatives. In that 302 report, FBI says Letter made the following admissions. He explained that the Select Committee was specifically appointed by the Speaker of the House and there were no majority or ranking members. There are, quote, no express rules for the Vice Chair Cheney as there would be for a ranking member. Letter went on to add, a copy of Section 3 was not provided to Costello with the subpoena. Said Costello never raised any objections to the requirement stipulated in paragraph 11. And so here saying that those were sent over turns out not. The statement by general counsel, they say, is an admission that the government's above representation that they sent the rules over is false. The general counsel's statement says that it's false. You said that you sent it over. You didn't send it over. Your own documents that you actually did send over. Look at your documents. It says you didn't send it over. Additionally, they write, it's an admission that pursuant to paragraphs that Mr. Bannon did not have to appear because the rules say when a subpoenaed person does not receive a copy, then that person doesn't have to appear. They are pointing to the rules. They say a witness shall not be required to testify unless that witness has been given a copy of the rules. See that? And they're saying your own counsel, general counsel of the House, is acknowledging that that didn't happen. And according to your own rules, he doesn't have to show up if that doesn't happen. The provision does not require that the witness make a specific claim under this section, right? So the witness doesn't have to invoke it or anything. You don't need some sort of affirmative volitional act from Steve Bannon or his counsel. Going through their own rules and showing exactly how this works. Says here, now this is where we're going to hear a little bit more about this fellow, Robert Costello. On page 3, the next false statement claimed by the government is that Costello failed to reveal that, quote, here's their false statement, quote, in the 11 days after accepting service of the subpoena, instead of gathering and reviewing the responsive records, Mr. Costello had spent the time searching for an attorney representing former President Trump. And you go, wait a minute, what is that? So the prosecutors are sort of speculating about all of this. They're saying in the 11 days after they got the subpoena, he didn't just go out there and just scurry around through his office, start rummaging through boxes, throwing cardboard all over the place. Where are the records? Just to gather them for, this fake January 6th select committee, which apparently is what they're implying. I guess he should have done. He could have been there, but instead he spent time searching for another lawyer. Well, I guess they know best, and if you send a subpoena and you're part of one of these, fake January 6th select committees, I guess you just have to do whatever they say. There's no due process for you anymore. You don't get to challenge it. You don't get to think about your own rights and privileges or consult with your lawyer or talk to other lawyers about any. You just do what they say, dang it. Otherwise, you're part of the problem. They say there is simply no basis whatsoever for the government reaching the conclusion, which they write obviously is entirely based on speculation and is in fact false. That's not what he was doing. He wasn't running around looking through a phone book or on Google. I wonder who is representing Donald Trump. Right? They're going to say there's no obligation for an attorney for Mr. Bannon to tell the government what he was or was not doing at any time. I can't believe it. Like they're actually writing in it. Hey, let me just confirm this for you in our Surreply. We don't have to tell you what the heck we're doing. We could be on a beach. We could be on an airplane with Donald Trump himself for all we care. Okay, doesn't matter. You don't get to tell us what we should be doing with our time. What a ridiculous statement. All right, goes on. Number 5, the next false statement claimed by the government, again on page 3. Page 3 had a lot of these. Prosecutor said, Mr. Costello seemingly did so, failing to gather and review the potentially responsive records because, quote, he was trying to help the defendant, Bannon, find a way to avoid compliance with the subpoena. Indeed, contrary to what the defendant suggests to the court, Mr. Costello told the government that he believed he may have attempted to contact Clark first. All right, so now they're talking about this other person who's investigating this. Here it says, again, the government is engaging in rank speculation about an irrelevant fact. They're sort of, I guess, projecting what they think he's doing. They've got no evidence of any of this, and it's not their business anyways. Who contacted who first, and they're ascribing falsity to defendant's counsel. Oh, here he says it. He says, I suggest they are projecting and not factually reporting about irrelevant details. The issue is whether the former president invoked the privilege, and he did. So whatever they're doing to talk about any of these things, right? If the president invoked executive privilege, and they're saying, well, that's the governing law. He was the president after all. And we're not going to be complying with that subpoena because we have a legal basis to do it. But they frame it sort of with this emotional conjugation of, avoiding compliance. Well, maybe he has no legal requirement to comply in the first place. But they're continuing to speculate, and they go back to this issue. We got a number 6, and then I think we're going to wrap it up. We see here, it says the next false statement claimed by the government, found on page 4, is that the former president never properly invoked the privilege. And the defendant and Costello knew this. Now, this we've heard a lot about. Benny Thompson, we have other legal scholars saying, well, this was never a formal invocation of any of these privileges. And Steve Bannon, because there was no executive privilege, can't use that executive privilege as a shield to protect himself from any criminal liability. So here they're saying, look, this is what they wrote in their dumb motion. They said the former president never properly invoked it, and the defense knew this. And they say, look, let's go through this again for you. They write here, once again, clearly a false claim, which is refuted by the very evidence the government cites. Open up your own briefcase. The evidence is in there. No, not that one, the other one. No, the other one. All right. Here it says Justin Clark telephoned Mr. Costello, Bannon's lawyer, and orally stated the president was invoking executive privilege, that he would later send a letter by email making the same invocation. the exhibits provided to the government by Mr. Costello and now provided to the court by the government clearly show that Costello stated that he was confident that executive privilege had been invoked despite Chairman Fishy Benny Thompson's incorrect statements that Trump had not formally or informally invoked the privilege. The request to Mr. Clark to contact the Select Committee directly was to simply stop the silly argument over Thompson's incorrect legal position. The email Mr. Costello provided to the government from him to Justin Clark stated, quote, "I believe it is clear that President Trump has invoked executive privilege." But Thompson appears confused as he continues to incorrectly reiterate that Trump has yet to formally invoke. To eliminate all doubt in the committee's mind, please confirm to the committee for the 35th time that Trump has invoked the executive and the attorney-client privilege. So Justin Clark apparently is somebody working on behalf of Trump, not investigating this, saying, look, I'm going to communicate this to you people. Invoked. If you need more clarity, here it is again. Invoked. One more time for you all there. Benny, I know you're slow. Invoked. Correcting the record. That was number 6. And it goes on until we get to number 12. Number 12 says, finally, look, there is the government's big lie that Costello's use of the word, quote, beware in an email was a problem. And they say, look, in an email that Costello voluntarily provided to the government. Yeah, like you read through our emails and you said, oh, there's a word beware in there. Like, oh, beware, like you're trying to, do something nefarious. All right. They say, well, first of all, we gave you the email. You think we're so dumb that we're going to say that we're going to include like evidence of our criminality in the emails we turn over to you? They say no. But they say here, provided to the government was to warn Bannon that his failure to comply could result in a referral to the DOJ, saying that this beware language was a warning on behalf of Bannon. They say, look, 12th false claim. They write, the government's claim is false. The warning was to Mr. Bannon to beware of Justin Clark. The email of October 14th actually stated, I don't know what game Clark is playing, but it put Steve Bannon in a dangerous position. That there was one statement that the government made in its response that we are in total disagreement with. It's on page 9 of its 28-page presentation. That one line says, the record above is littered with bad faith. That's from the government's 28-page motion. They say, we agree with that statement. On page 8 of 9, after they've just gone through 12 false statements, they say, we agree with this statement. The record above is littered with bad faith. The government's bad faith. They say this aptly describes the government's 12 false statements trying to unsuccessfully impugn the integrity and the veracity of Mr. Costello. They write, wherefore, for the foregoing reasons, Bannon requests this court consider the foregoing surreply as part of the record and deny the government's motion in limine to stop the discussion of this good faith reliance on advice of counsel. You can see signed off on here by Evan Corcoran, Robert Costello, and you probably recognize this guy down here, David Scone, over from, where is he? Alabama, but he represented Donald Trump back during, I think, impeachment 2, maybe even impeachment 1. I don't know. Donald Trump, though, 2 for 2 on the impeachment game. Steve Bannon looking like he's building up a pretty decent case here against the government. I mean, their emotions are looking a little bit wanting to some degree, and certainly feel like blatantly false statements to me. Now, I know some people might say, that's just shocking. Prosecutors would do that. Well, sorry, folks, it's true. And here we see it. Now, we're going to see what the judge says about all this, of course, is to go in front of the judge. The judge will make a ruling. What's going to happen with some of these issues, we don't know. 3 big motions still under advisement. We get a ruling on them. We'll be certainly sure to make sure we dissect them and see exactly how this case unfolds. I hope you join us as we continue that journey. Don't forget to subscribe or share this video with a friend or family member so that everybody can really see what's going on here. And I look forward to seeing you on the next one.